Okay, so we've been looking at civil liberties, and now we're going to turn our attention to civil rights. And I think I've said this before, but remember the difference between civil liberties and civil rights. Or civil liberties are your protections against the government, and civil rights are your protections by the government. And so we have a long and storied history regarding civil rights in America, as you well know. And so we're going to briefly look at the historical significance of civil rights and understand this is not a history course. And so we will not be doing an exhaustive, in-depth analysis on civil rights, but we are going to hit the high points and show the progression of civil rights throughout our nation's history. And so we know the fight for civil rights goes back all the way to the founding, but it's not really going to be until after the Civil War that they really come to the forefront of our nation's history. And so in 1868, following the Civil War, we have the 14th Amendment passed. And the 14th Amendment has the Equal Protection Clause, which states that no state shall make or enforce any laws which shall deny to any persons within its jurisdiction the equal protection of the law. And so this gave the appearance of an equal society, but the Supreme Court wasn't really prepared to enforce the amendment. In 1875, the Congress will pass the Civil Rights Act of 1875, which attempted to protect blacks from discrimination by hotels, theaters, and other public accommodations, but the Supreme Court actually will declare this unconstitutional. And they do this by saying that the 14th Amendment was intended to protect blacks from public officials, not from private businesses. And so the fight for civil rights really isn't going to gain much traction for 100 years after the passage of the 14th Amendment. And civil rights is really going to be characterized for a very long period of time, 60 or so years, by this doctrine of separate but equal. And in 1896, there's going to be this Supreme Court decision called Plessy versus Ferguson, which really becomes a stain on American history. And the decision is based on a Louisiana statute that required segregation on trolleys and other forms of public transportation. Homer Plessy, who was part African American, had violated this law of separate but equal, and he was fined $25. Now, $25 is equivalent to about $730 in today's money, so it was a lot of money in 1896. But the Supreme Court will rule that separate but equal is fine, and this will be solidified in American law, and it will last all the way up until the mid-20th century. So as we progress through time, it's not going to be really challenged until some of these education rulings that occur. And one of these education rulings is going to occur in 1938. It's a very small chip away at the separate but equal idea. And in Missouri, there was a law that provided tuition money for qualified blacks if they would attend out-of-state law schools rather than admitting them into the University of Missouri Law School. And so it essentially outsourced African Americans to other states, and it would pay for them if they would go to these other states. And the court did rule this unconstitutional, and this was again in 1938, but they're not really going to deal with this again until 1954 with the famed Brown versus the Board of Education decision in 1954. Now, a little bit of history behind this 1954 ruling. Multiple suits had been filed in federal court in 1952 regarding education, and they were filed in places like D.C., Delaware, Kansas, South Carolina, and Virginia. And so the court was going to take up one of these cases, and they decided to take up Kansas because it was farther along in the district courts and it was not located in the Deep South. And so what this is it's a case that stems from an incident with Oliver Brown and his child Linda Brown. Linda had to walk a mile in dangerous neighborhoods to the bus stop in order to be bused across town to school for black children, although the white school was much closer. And so Oliver decides to take Linda to the all-white school to enroll her into third grade, even though it was against the law. The school refused, and so Brown took his case to the NAACP, and soon after, Brown versus the Board of Education was born. Now, what happens is, in 1954, the Supreme Court will rule that states no longer had the power to use race as a criterion of discrimination in law. Secondly, the national government from then on had the power and the obligation to intervene with strict regulatory policies against the discriminatory actions of state and local governments, as well as on the school board level with employers and many others. So it essentially overturns that idea of Plessy versus Ferguson, and it's a huge step in the right direction in the movement for equality for all races. But even after it was instituted, 10 years later, after the case was instituted, only fewer than 1% of schools were integrated. But it does give it will give a little bit of a push for the civil rights movement. And eventually, with the momentum that occurs, Congress is going to have to step in and remedy the issues associated with racism and segregation in society. And so the Civil Rights Act of 1964 is going to be a big piece of legislation, and it essentially integrates the public. And so signs denoting white and colored accommodations are going to be removed from restrooms, water fountains, waiting rooms, seating arrangements. And soon after the passage of the Civil Rights Act of 1964, the federal government will file more than 400 anti-discrimination suits in federal courts against hotels, restaurants, taverns, gas stations, and other public accommodations. But by no means is the fight for equality over. There's still much to do. And in regards to school desegregation, the Civil Rights Act of 1964 also created administrative agencies to help implement new anti-discrimination laws. And so even though Brown versus the Board of Education had ruled against segregation, it hadn't been implemented, and so the Congress is going to step in with the Civil Rights Act of 1964 to assist in integrating public schools. It also dealt with employment. The Civil Rights Act of 1964 outlawed job discrimination by all private and public employers that employed 15 or more workers. And in order to enforce some of these practices and some of these, the push for equality, the government, if a company was engaged in business with the government would revoke public contracts for goods and services. So it did have a little bit of teeth in that regard. Voting is also a significant aspect of civil rights because there was some disenfranchisement of certain groups within society. And so there's going to be the Voting Rights Act of 1965 that will be passed. And in 1965, with the Voting Rights Act, the federal government will bar literacy exams and other tests as conditions for voting. 6 southern states had employed these types of methods to disenfranchise groups of people. And they would also provide for federally appointed registrars to replace state and local registrars if there was intervention in voting. So if local officials tried to intervene in certain groups taking part in the voting process, then the federal government would step in and remove those individuals and replace them with federally appointed individuals. The 24th Amendment is going to be passed in 1964 that will abolish the poll tax. And so it's going to abolish this idea that you actually have to pay money in order to go vote. So it removes a barrier that prevented poor people from going and voting. In 1964, we'll also see the federal government mandating bilingual ballots or oral assistance for speakers of Spanish, Chinese, Japanese, Korean, and native languages. So it's going to assist individuals who are not necessarily fluent in English, and it provides some assistance in their own language. We still have the fight for voter rights today. There's a lot of concerns regarding voters' rights, and this really stems from voting ID laws in modern time. Um, some states require that you have a federal or a government issued identification. Excuse me. In order to vote, and so this is going to be one of the things that we still fight in modern day. In regards to housing discriminatory practices, the Fair Housing Act of 1968 will be passed, which outlawed housing discrimination in the sale or rental of most housing, which will eventually cover nearly all of the nation's housing. However, the mechanisms were extremely weak in the Act of 1968. It was left up to individuals to prove that discrimination had occurred, and sometimes it's very hard to prove that discrimination has occurred. It's a very sometimes it's very subtle, and so it was very difficult for individuals to be able to prove that. And so in 1988, about 20 years later, it's going to be altered. These procedures were altered to put more of the burden on the individual discriminating to prove that they had not discriminated, and it will develop the Department of Housing and Urban Development at the federal cabinet level to assist in fighting these types of practices. We typically will associate civil rights with African Americans' fight for equality, and rightfully so, but there are other disadvantaged groups out there that have fought for equality as well, and one of those groups is going to be women. Now, we know that, or you should know that, women didn't even have the right to vote until the passage of the 19th Amendment in 1920. So it's been less than 100 years that women have actually had that right to vote. And so seeing the success of the African American civil rights movement, the women are going to start creating certain groups, the National Organization of Women, who will picket against sexist employment practices, the Women's Equality Action League, which pursued legal action against law schools and medical schools for discriminatory admissions policies. Activists sought to add an equal rights amendment to the Constitution, and it was a very short amendment. It simply stated that equality of rights under the law shall not be abridged by the United States or any state on account of sex. And the Congress is going to very easily pass this in 1972. But over the course of ratification, only 38 states will ratify it, and the necessary number for ratification would be 41, and it's going to fall 3 short of that number. And so the Constitution, constitutional amendment was actually never ratified by the state, so it did not go into effect. But the Supreme Court will step in and help establish gender discrimination as a big civil rights issue. It does not treat gender rights in the same way that it treated racial discrimination, but it did make it easier for plaintiffs to file and win suits on the basis of gender discrimination. And then in 1972, in the Education Act, there's going to be a clause in this Education Act called Title IX, which is going to forbid gender discrimination in education. And it's going to initially spark little litigation because of its weak enforcement provisions, but in 1992, a court decision will deem that monetary damages could be awarded for gender discrimination. And so it's really going to open the door for more legal action in the educational arena. And so the biggest areas that this will affect is sexual harassment and women's athletic programs. And so if you've ever been a part of an athletic program, there is a thing called Title IX that deems that men and women's athletic programs must be equal. And so that's been a big fight across the United States for a period of time. In 1996, another step for gender equality was taken when the court will put an end to all male schools supported by public funds. And so some of these military schools that had been male only for hundreds of years since their inception, are no longer going to be able to bar women from joining. And then there's a lady called Lilly Ledbetter, and she had worked in a company for a very long time, and she later found out that she had been paid 40% less than her male counterparts. And so she will sue in regards to gender discrimination, but the Supreme Court will deny her claim because workers must file a grievance 180 days after the discrimination occurs, and it had been occurring for a very long time. But in 2009, President Obama will sign what is known as the Lilly Ledbetter Fair Pay Act, which gives workers expanded rights to sue in cases such as Ledbetter's. And so there will be that step in the right direction for gender equality. Latinos and Asian Americans have also been disadvantaged groups within society. And so limited English proficiency hindered some Latinos and Asians from participating in American life. And in 1974, the Supreme Court will rule that schools have to provide education to students so that the students could understand it. Meaning, it does not have to be bilingual, but it must accommodate their limited English proficiency. And so as a result, in schools, we do have LEP programs to assist these English language learners in their pursuit of an education and in a pursuit of learning, their accommodations in participating in the educational setting. We have already talked about the abolishment of literacy tests and the mandating of providing ballots in other languages, but there are still obviously significant issues associated with these groups today, and so they still are disadvantaged groups that have not received equality 100%, and obviously there's no disadvantaged group that has received equality 100%. Native Americans are going to be a marginalized group. In 1975, Congress established that Native Americans be taught in their own languages, and Native Americans have been suing the U.S. for sovereign status, which would allow Native Americans to be much more self-determinant in some of the laws and things that they abide by and some of the regulations they're beholden to. And in 1987, the court will decide that Native Americans are actually free from most state regulations prohibiting gambling. And so this will allow many Native American tribes to engage in creating casinos and making money in that way. Another group are going to be disabled Americans, and in 1973, the Rehabilitation Act will be passed, which outlawed discrimination on the basis of disability. In 1990, the Disabilities Act is going to guarantee equal employment rights and access to public business for disabled Americans and bar discrimination in employment, housing, and healthcare. And so, there's going to be some protections put in place for disabled Americans. And then one of the big areas in which there's a fight for civil rights in modern day is going to be gay rights. This has become one of the largest civil rights movements in contemporary history, and America's history regarding gay rights is very storied. And so early on in the 1940s and 50s and times like that, gay and lesbian individuals were seen as sexual deviants, and they were seen as suffering from a psychological disorder, and many states will criminalize sexual acts. In 1986, we had the first Supreme Court case on gay rights, which ruled against a right to privacy that would protect consensual homosexual activity. So we even have some Supreme Court laws that do not protect homosexuals in their pursuit of sexual activities. And so there's really quite a bit of anti-gay decisions and laws out there until about 1996, when the Supreme Court strikes down a Colorado state constitutional amendment that banned local governments from passing ordinances that protected gays and lesbians. So if you are a city or a municipality and you passed an ordinance that protected the rights of gays and lesbians in Colorado, the Constitution of Colorado actually forbid that, and so it was very discriminatory. The court will step in and equate gay rights as civil rights, so it's going to really push this these gay rights into the civil rights realm. And in 2003, the Supreme Court case overturned the 1986 case that we had just talked about and struck down a Texas law that made certain sexual conduct between consenting partners of the same sex illegal. And so it essentially strikes down laws that make homosexual acts a crime. It did not change the federal and state laws that deprived gay people of full civil rights, including the right to marry, but it's going to be the step in the right direction. In 2013, the Supreme Court will strike down the Defense of Marriage Act, which barred benefits to same-sex couples and allowed a California law to recognize same-sex marriages. And then in 2015 comes the big case called Obergefell versus Hodges, which is a court case that ruled the Constitution's Equal Protection Clause of the 14th Amendment guaranteed same-sex couples the right to marry in all states and required states to recognize such marriages performed in other jurisdictions. So it essentially legalized gay marriage and insisted that states take part in issuing marriage license to same-sex couples under the 14th Amendment's Equal Protection Clause. And so the fight for civil rights is something that has occurred in many different areas of society. We typically associate it with African Americans, and rightly we should, because that's the biggest fight that has occurred since the inception of our nation, but it does incorporate other disadvantaged groups as well. And so we're going to leave off here, and I'll see you in the next lecture.